Today, we are excited to look ahead to our work during the Connecticut General Assembly's legislative session, which begins in just a few weeks on Wednesday, January 4th. We have been preparing for the long session and are very excited to share with you some of the important issues that we will be focusing on next year. Before we begin, please note that closed captioning is available. You can activate that by selecting the closed captioning button at the bottom of your screen. And a special thank you, of course, to our ASL interpreter today. I am happy to be joined this afternoon by some of the folks in the ACLU of Connecticut's Public Policy and Advocacy Department that I have the privilege of working alongside. So I'm going to ask everyone to kindly introduce yourselves, your names, your pronouns, and your positions here at the ACLU of Connecticut.
Hey, y'all. My name's Claudine Constant, pronouns she, her, hers, and I am the Public Policy and Advocacy Director.
Hello, everyone. My name is Anderson Curtis. My pronouns are he, him, his, and I am the Senior Policy Organizer.
Hey everyone, I'm Jess Zaccanino. I use she, her pronouns, and I am the Policy Counsel.
Thank you so much. If folks who are watching have questions, we will have a Q&A session at the end, so please feel free to type in your questions in the Q&A section, which you can also find at the bottom of your screen, and we will do our best to answer your questions again at the end of the webinar. All right. Now, before we jump ahead to January, I would like to take a moment and appreciate a big win for the people of Connecticut on Election Day, November 8th, just I don't know, 4 or 5 weeks ago, when over 60% of voters said yes to the early voting ballot question. Voting yes was an important vote to give more people more power at the ballot box. It was an important vote for racial justice, for women's rights, for disability justice, and for families, and to make sure voting isn't just a luxury for people with more time on a Tuesday in November. And here at the ACLU of Connecticut, we started a political action committee for the first time. We created the ACLU of Connecticut Rise PAC, and with our canvassers, we knocked on over 1,500 doors in communities across the state and had hundreds of conversations with people to talk about voting, if they knew about what early voting was, where it was located on their ballots, and why we needed early voting here in Connecticut, because we are one of only 4 states in the country that does not have early in-person voting. I'd like to bring in Anderson now, because in addition to canvassing and door knocking, what were some of the other voting initiatives that you were working on during this past election season?
Thank you, Gus. Some of the other work that I was doing within the RISE program was for the voter registration for people on parole. And that was highly significant this year because that was not an option last year. That was not on the table. That was something that we worked with other community partners to pass a policy into law. So people on parole now have the right to vote in the state of Connecticut. So doing that voter registration work, I was able to talk to over 147 people at 13 different voter registration events, collaborating with 11 community partners. That yielded 46 people registered to vote on parole. And one of those people, I actually had the privilege to accompany him to the polls. And afterwards, he explained to me the significance of him casting his ballot for the first time, the significance of that experience for him. And that pretty much was very priceless. So thank you, Gus. That was my contribution to the work.
Thank you, Anderson, for sharing that. And that's really amazing to hear about. And that's a big win for everyone. That's a big win that's going to strengthen our democracy here in Connecticut. And there is more work that we need to do. Now that the voters have spoken, it is going to be up to the General Assembly to create a plan for early voting. So I'm going to ask Jess what the General Assembly now needs to do for early voting in the next session, and then what other voting rights issues we are going to be working on next year.
Yeah, so as Gus just said, Connecticut voters didn't vote to institute a particular early voting plan when we voted in November. We just gave the legislature the ability to pass laws about early voting. which means it's up to us to keep up the pressure on legislators to pass an equitable early voting law this session. Leading election law institutions like the Brennan Center for Justice have found that through evidence-based research, that approximately 14 days of early voting is the optimal amount of time to maximize early voting turnout. Any less than that and participation starts to drop off. So states with less days like Oklahoma, which currently only offers just 3 days of early voting, they tend to experience pretty low rates of early voting. Oklahoma sits at about 8% turnout and when they vote early, which is quite low. Weekend voting days are also important for working people. And Sundays are particularly important because of the Souls to the Polls movement, which was rooted in the civil rights era of the 1960s. The Souls to the Polls is a day of action coordinated by Black faith leaders who organize on the Sunday before the election to coordinate transporting folks to the polls after they worship. And studies of states with early voting days on the Sunday before the election have found that the day that was by far the most popular early voting day for Black voters was those Sundays. So showing that this is also a racial justice issue and making sure that whatever early voting plan we have is inclusive. Night voting options are also important for people that are working long hours or whose work schedules are unconventional or who might not have access to childcare during the daytime. But in addition to early voting, we will also likely be hearing a bill again to run a similar constitutional question, but for no excuse absentee voting. We're one of only 15 states without no excuse absentee voting. So right now you need about, I think it's a list of 6 reasons or so to vote absentee. So that excludes a lot of people from being able to vote that way. And a majority of states that offer early voting also have no excuse absentee voting. So these two tie together because using no excuse absentee voting further alleviates stress on voting in person early. And because we still don't have accessible no excuse absentee voting in Connecticut, we'll be plagued with more unnecessary additional stress when our election system starts to vote early since we don't have no excuse absentee voting. And finally, one other big piece of voting rights legislation is the Connecticut Voting Rights Act. This is legislation that's been raised in the past 2 sessions in response to the Supreme Court's radical curtailing of the decades-old Federal Voting Rights Act of 1965 through cases like Shelby County v. Holder, Bronovich v. DNC, and this term in Merrill v. Milligan, which is challenging a particular section of the Voting Rights Act of 1965. So the Connecticut Voting Rights Act would institute the protections of the Federal Voting Rights Act at the state level to protect it, at least here in Connecticut, but while also expanding its scope, building on what we've learned over the decades since it's been instituted. So, for example, this would result in increased language access, both by expanding the scope of language assistance beyond the 10 or so towns that are currently covered in Connecticut by the Federal Voting Rights Act, while also making advancements beyond those standards, like, for example, using cost-saving technology recently developed by the Secretary of State's office that would include live translation service systems, providing translation in most languages done by real live people in video calls. This wouldn't be a Google Translate kind of thing. And because it would be on video calls, this would be accessible throughout the states, so even more rural areas, we could get somebody in there online, which would be great. It would also launch a pre-clearance program that puts the burden on local governments with records of discrimination to prove that certain voting changes won't harm voters of color before these laws even can go into effect. And it would also provide new legal tools to fight discriminatory voting rule changes in court and create stronger protections against voter intimidation, deception, and obstruction. That's all a whole lot. And we might even be seeing some additional legislation pop up, but who knows, this will be a big session for voting rights for sure.
Yeah, thanks so much, Jess. It is a lot. There's a lot that we need to do. And thank you for making that distinction between early voting and no excuse absentee voting and the Connecticut Voting Rights Act, which we're going to be paying a lot of attention to each of those during the next legislative session. Access to voting has been and continues to be a racial equity issue. And you'll find that most, if not all, of our legislative priorities will have a racial equity framework, particularly when it comes to our work on the criminal legal system, where we've been focused on both the front end and the back end of the criminal legal system. Claudine, could you explain a bit more about what that looks like, as well as the work that we are continuing to focus on when it comes to the system of policing here in Connecticut?
Absolutely, Gus. So what we mean when we're saying the front end and the back end of the criminal legal system is really taking a large view of how the system works together as a whole, right? So when we're talking about the back end of the criminal legal system, we're referring to the barriers and the circumstances, otherwise known as the collateral consequences, a person faces when living with a criminal record after coming home from Connecticut's prisons and jails. This means people are being systematically locked out of job opportunities, access to quality housing, and educational opportunities. The front end of the criminal legal system looks at the actors and the systems that directly funnel people into Connecticut's prisons and jails, police and prosecutors. The biggest thing to keep in mind when looking at the criminal legal system as a whole is that police and prosecutors are ultimately the deciders on who gets arrested and who doesn't. Police and prosecutors' discretion is at the heart of this conversation, and time again, all facets of the criminal legal system show that Black and Latinx people are over-policed, over-prosecuted, and underprotected. One policy priority we're tackling to address the front end of the criminal legal system, along with several other community partners, is the active deceptive interrogation practices by police. We're seeking to have this practice abolished in our state. Deception refers to the currently legal form of interrogation when investigators can lie to a person about evidence linking them to a crime, penalties they could suffer, or leniency they could be offered in order to coerce a statement or a confession to the crime being investigated. There are several consequences of deception, but the two biggest are wrongful convictions, resulting in people losing decades of their life for a crime they didn't commit, and an extensive financial burden for the state of Connecticut. Last legislative session, this bill made it out of the Judiciary Committee, was voted out of the Senate, but died in the House. We're hoping it clears both chambers this year and makes it to the governor's desk this upcoming session.
Thank you, Claudine. And you mentioned another one of the central issues that we have been working on for a number of years on the Smart Justice campaign, going back to the very beginning of the campaign, which are state's attorneys, prosecutors, and the role that they play in the criminal legal system here in Connecticut, which is in many ways different than across the rest of the country. We've been deeply involved in the work in recent years around creating transparency for prosecutors and accountability for the chief state's attorney. And there's a lot more work that the General Assembly still needs to do. So Anderson, can you talk about the work that we will be doing to continue to bring accountability to all of Connecticut state's attorneys?
Yes, Gus, definitely. So one of the most important parts of an act concerning prosecutor accountability, because as we well know, prosecutors are one of the most powerful actors in the criminal legal system, and also among one of the least accountable. Connecticut state's attorneys serve 8-year terms. During those 8-year terms, there's no opportunity for public input or the Criminal Justice Commission for oversight of their performance. According to a 2020 survey, that 86% of Connecticut voters supported making state's attorneys undergo data-driven performance review every 2 years. So as the CJC will be required to evaluate these state's attorneys every 2 years based on data that we already have from OPM, with opportunities for the state's attorneys to explain the data, but more importantly, in another facet that's going to extend the transparency we would create publicly available biennial reports summarizing each state's attorney's performance based upon that data already collected. And so, this is a very important bill. This is one of our legacy bills, and we will work hard this session to get it across the finish line with the help and support of the people of the state of Connecticut and our other community partners. Thank you very much, Gus.
Absolutely. Thank you, Anderson. Before we move on to our final legislative priority, let's take a moment and pause and open up the Q&A to see if anyone has a question about our voting work and or our work on the front end of the criminal legal system. All right, here's the first one. I guess this would be a question for Claudine. Would Connecticut be the first to end deceptive police practices?
No, so Oregon and Illinois have already taken the first step in abolishing deceptive interrogation practices for children. And it was a bill that was bipartisan support. So not only were people that are fighting to reduce the size, scope, and power of police in support of this bill, but prosecutors, law enforcement, and law enforcement trainers were all in favor of this bill. So we're hoping to see some movement here in Connecticut, and ideally it would cover everybody, not just children.
I guess I have a follow-up question to that too, Claudine, for you. Does the Innocence Project have a dollar amount for how much has been paid out to innocent people who have been incarcerated by the state? Yeah,
so far Connecticut has paid out almost $50 million. So $37.5 million in compensation for wrongful convictions, in addition to the 10.7 million in known civil settlements. So once people are exonerated and come home from prison, obviously they seek some kind of relief for the damages and the lost time that they've experienced, resulting in, again, almost $50 million in lost money to the state of Connecticut.
Thank you. I got another question here. I think this one is probably for Jess. Can you provide the Brennan Center recommendation for 14 days of early voting?
Yes. Do you know if there's a way for me to drop it in the chat for everyone to see? I have the link. I don't know the best way for.
I think, yeah, we just posted a link to the Brennan Center report. Thank you. Do we have any other questions? We'll do questions at the end too, so folks can still put one in. All right, I'm going to go back to Jess again to talk about a newer issue that we are working on, which is a civil rights bill for Connecticut. Can you explain what that is?
Sure. So this is one of our more technical bills, so bear with me. But this bill essentially came about because we're experiencing a contraction of the ability of individual people to sue to enforce their rights under the federal Constitution through a piece of legislation called the Civil Rights Act of 1871, which also for the lawyers in the audience is colloquially known as Section 1983. Essentially, that law seeks to compensate people or seeks to allow people to be compensated when their constitutional rights have been violated. It also works to deter individual officers and policymakers through threatened liability for these awards, and also seeks to articulate legal norms and shape the policy choices of all main actors. So this means it's the primary way that people can sue the government, and it's a vital tool for people and organizations like us that do civil rights litigation. So, for example, we saw these rights shrink again this past term in a case called Vega v. Tico, where the Supreme Court narrowed the circumstances as to when people can pursue this kind of legal action when their Fifth Amendment Miranda rights were violated by police in certain circumstances. But at the state level, so that all concerns federal law. But at the state level, we don't have an equivalent law that would guarantee the same kind of protections at the state level through the Connecticut Constitution. So this is what we want to do through the Connecticut Civil Rights Act. Adopt a statute like the one at the federal level, which would allow people to pursue private legal action in civil court against state actors like police officers, corrections officers, or other peace officers when their fundamental rights are violated. Rights, really mean nothing when there's no adequate means to realize or enforce those rights. So what we're trying to do here is open up a door for people to receive these remedies when their rights have been violated, as we're seeing that same door close at the federal level in spite of decades of legal precedent. So in addition to allowing a cause of action for people to enforce their rights in court, allowing people to get monetary relief, this bill would also this bill would also allow prevailing plaintiffs, so the folks that are suing, to recover reasonable attorney's fees and costs to make it easier to launch a lawsuit, while also ensuring that states and local governments indemnify their employees in situations where their failure to insure those employees who might be sued would leave the plaintiff without a way to recover whatever money they might want in a judgment. So it also, protects folks on that end. And there's important monetary incentives for this bill too. So by increasing the risk of private enforcement for these violations of fundamental rights might ultimately save the government agencies some money by deterring people from committing future violations, decreasing the cost of defending against future lawsuits and settlements. We wouldn't be the first state to explore something like this. States like Colorado and New Mexico have passed bills similar to this in recent years. And there's been efforts all over the country to pass similar legislation, like our neighbors in New York and Vermont.
Thank you, Jess. Once again, that sounds complicated and like there's a lot there, and we have our work cut out for us beginning in January. As we begin to wrap up, and thank again to everyone for spending your lunchtime with us, I want to open it up to everyone on the panel. What else do we think will be coming up during this legislative session that we will be paying attention to?
I'll go. Two things that I think are really important for us to monitor, right? The first thing to acknowledge is that there are a lot of proactive bills that us and community partners are introducing to continue to push Connecticut forward so that everybody has an opportunity to thrive, right? But in that, we also need to be paying attention to some of the defensive bills that actively try to roll back the progress that Connecticut has made, particularly in the work to reform and rebuild our criminal legal system so it better serves people in Connecticut. We'll see constant attacks on the police accountability bill. We'll see constant attacks on voting rights and, many access to reproductive services as well. So it's important for us to pay attention to not only the proactive bills that push us forward, but pay attention to the defensive bills. So if you're able to get up there and testify and tell them why you want people to invest in Connecticut, do it. The second thing I want to highlight that I know will be moving through this session as it relates to the back end of the criminal legal system. So the collateral consequences people face when coming out of Connecticut's prisons and jails is a bill that addresses the collateral consequences to housing. We find over and over again that people who are living with a criminal record actively face barriers to achieving and living in a quality apartment that can be affordable too. And so we're really hoping to reduce that barrier or to eliminate that barrier, because once a person has done their time, paid their debts to society, they deserve an opportunity to move on, and that includes having a roof over their head. So.
Yes, thank you, Claudine. Anyone else? We can turn back to the Q&A and see what other questions folks might have. Here's a question, we'll throw it out. What are the most typical examples of prosecutorial leeway, and does the public know about these changes? I wonder if leeway is like a synonym for discretion.
Yeah, that's what I'm trying to, if leeway is a synonym for discretion. Anderson, did you want to take this?
Sure, yeah.
Yeah.
One of the things that word discretion is very broad. And so, prosecutors utilizing some of the diversion programs that are at their disposal, right, more often than not, right? And it just increasing the use of those diversion programs, and also just helping people have an outcome from the criminal legal system that does not end up in incarceration, right? So one of the conversations that we have, and one of our values here at Smart Justice, is that everyone has a role in any mass incarceration, and that includes the chief state's attorney and the prosecutors in our state. And so we will continue to push hard at the table for what that role looks like, and to expand that role, and to have many more conversations, because again, we are coming at this from the front end, from the back end, and we are at the table talking with people, but more importantly, advocating for those to have a better outcome that does not include incarceration, that does not include time away from their family, and does not include a major cost to the state of Connecticut.
Yes, thank you, Anderson. We are almost out of time, so well, I'm going to just wrap it up right here. Thank you, Anderson. Thank you, Claudine. Thank you, Jess, for joining us today. And I also want to give a shout out to Taylor, Laura, and Amber for developing and planning this webinar. If folks want to learn more about how to support any of the work that you heard about today, please reach out to us. You can email us at info@acluct.org, and we will connect you with the right person. There will be a recording of this webinar and this conversation on our YouTube page. And then again, please stay in touch and keep up to date with all of our work at our website, ACLU-CT.org, as well as on our social media pages. Thank you, and enjoy the rest of your Tuesday.
Thank you, everyone, for your time. Thank you.